about the discipline system, give you an overview of how it works, give you and direct you to certain points in case law that will hopefully educate everyone here and prevent people from actually coming into the system. As Chief Trial Counsel, I am in charge of the office that investigates and prosecutes attorneys for misconduct. And so let me tell you a little bit about our office. On average, we receive anywhere between 14 to 16,000 complaints a year. That is separate from our complaints hotline, and our complaint hotline receives about 4,000 calls a month. We have a large membership here in California. We have over 240,000 lawyers. 170,000 plus of them are active. So even though my office sounds large and complaints sound large, the percentage of lawyers that actually get into trouble and are seen by my office is actually very small. On average, there's about 1,000 attorneys every year who are under some kind of disciplinary order or probation condition from the state bar court, and so that gives you a general idea of the scope and volume of what our work is. So, what happens if a complaint comes into the State Bar of California? It is referred to my office, which is the Office of Trial Counsel. We have an intake department that receives complaints. Complaints are required to be in writing, and that is because if someone is making a complaint against their attorney, we want to ensure that the attorney-client relationship, the privilege is waived, so the client actually has to fill out a form and submit that in writing to us, and that begins the complaint process. Intake takes a quick look at that complaint for the determination of whether or not there is an allegation of something that we should be investigating. If that's the case, intake forwards it to investigation. They make just a very preliminary call at the beginning. In investigation is when it's assigned to an attorney and investigator to actually investigate the case. And what happens then is, if a formal investigation begins, we actually are required to write to the attorney to advise the attorney of what the allegations are and give the attorney the opportunity to respond to those allegations. If after the completion of the investigation it looks like we have violations based on clear and convincing evidence, it proceeds to a pre-filing status, which is we contact the attorney to see if this is something we can resolve pre-filing. If not, then we file charges before the state court. People often ask me generally what are the types of complaints that we get, and this graph here kind of shows you breaking down by areas of the types of complaints. And to no surprise, most of the complaints that we get are complaints alleging some kind of performance violation. The next big area is fees. That should not be very surprising. It's where a client is complaining something about either mishandling fees, unrefunded fees, etc. In 2009, we experienced a spike in complaints involving loan modification and foreclosure relief. I'm sure that's not a surprise to everybody. In 2009, we started tracking those complaints because it hit us like a wave. And it really increased the number of complaints that we got. So let me give you an example. In 2008, we received approximately 14,000 complaints annually. By 2010, it had jumped up to over 17,000. We believe we've now tapered off, and we think actually in 2013 we'll return back to sort of normal volume, and we'll probably close around 14,000 complaints. But that boom really impacted the state bar significantly and increased the number of cases that were actually investigated and cases that actually went forward. To give you an example, since 2009, there were over 13,000 complaints submitted to the state bar regarding loan modification or foreclosure allegations. Of that, 10,000 went forward to investigation. As of October this year, there were approximately 200 plus lawyers who had already been subject to formal charges in the state bar courts. And that gives you a general idea. So I want to talk to you a little bit about sort of the common types, the notable types of misconduct that we deal with. Intentional attorney misconduct, no surprise to anyone here that is a problem. So any intentional misrepresentation by a lawyer will likely put you in the Office of Chief Trial Counsel's arena. And any intentional misappropriation is a potential violation, obviously, of your ethical duties. And so what has happened is sometimes attorneys will be referred to us, and through the course of the investigation, they have made misrepresentations to us. Intentional, grossly negligent, etc. That by itself is a violation. Even if the underlying complaint goes away, that is a separate violation that my office investigates and can prosecute. Obviously, an attorney who intentionally deceives a client, that's an act of moral turpitude under the case law. Concealment is considered the same as misrepresentation. So what does it mean, intentional misconduct, willfulness? In the state bar court system, simply a purpose or willingness to commit the act is enough. It does not require an intent, obviously, to violate any rule or statute or to injure another. Simple negligence is not disciplinable. However, gross negligence is. And so what do I mean by gross negligence? I'm not going to go through all of these for you because I know that we're short on time. And if anyone is interested in this PowerPoint, I will give it to Lisa or even Teresa Hurley for distribution. But when we're talking about gross negligence, recklessness, we are talking really about a pattern or behavior, It's repeated. That can get you in trouble. So even though an act of civil negligence would not be something to be disciplined, if it's repeated, if it gets to the point where it is reckless, that would bring you into the arena of the state bar court's disciplinary process. So let me give you a couple examples of what gross negligence fact patterns look like. This is straight out of some cases that actually were heard in the state bar court and then were it also went up to the Supreme Court. An attorney's office practices. If an attorney is basically delegating responsibility to non-attorney staff, so it's non-attorney staff who are doing everything. They're doing the intake, they're giving legal advice, they're giving legal consultation, they're actually splitting fees with non-lawyers. Things like that can get you into trouble. Not having a calendar system in place that really affects, like I'm saying again, the pattern of recklessness or gross negligence can get an attorney into trouble. Repeated habitual delays, missed deadlines, mishandling of money matters, even if it's not for misappropriation or personal use, can get an attorney into trouble. Client misconduct. I get asked this question a lot. What if you are representing a client and it's really the client who's doing the misconduct and not you, the attorney? Again, I'm going to point you to some cases here to take a look at. But basically, if you look at Young versus Rosenthal, if you have a client who's basically asking you to file false declarations, to commit perjury, obviously that's going to be a problem. And what an attorney should do under the case law is persuade the client otherwise or withdraw. Attorneys have been disciplined by the state bar court and approved by the Supreme Court for knowingly submitting false declarations by the client. If the attorney knows or should have known that the client is submitting false information, the attorney can get into trouble. So let me also back up here for a minute to make sure that you understand how the state bar court works with the Supreme Court. When discipline is recommended by the state bar court, it's a recommendation. The state bar court submits that recommendation, and that's based on facts and findings, conclusions of law, and submits it to the Supreme Court. The Supreme Court is the one that approves or rejects that recommendation. If the Supreme Court approves and accepts the recommendation, it issues out an order. It's a disciplinary order. And the discipline generally goes into effect 30 days after that order. So that's what I'm talking about when I'm saying the Supreme Court as well. It is ultimately the Supreme Court that approves the discipline. I want to take time to talk to you about MCLE, and I think it's appropriate given that this is an MCLE program. And hopefully all of you are aware that the state bar is now auditing attorneys on MCLE compliance. And I don't say that to scare you. I say that because I want to avoid seeing attorneys before me, before my office on this. My office, because we're the prosecutors, we don't do the audits. We don't deal with MCLE compliance. That's a separate area of the state bar. So if you have questions about, your particular MCLE compliance, I can't answer those questions. But I do want to tell you what the audits have meant for my office, and hopefully avoid future referrals coming. Because in the end, the state bar doesn't want to see any lawyers in the discipline system because of MCLE non-compliance issues. That's the truth. So in 2011, the state bar began these audits of MCLEs. And in 2011, they took a small percentage of the membership, 1%. And they audited those attorneys to see if they had in fact, complied obviously with their MCLE, but also during that audit process asked the attorneys to produce proof of compliance. 98 members were out of compliance. 5 members enrolled in inactive for failing to respond to the audit altogether. So if you fail to respond to the audit, you will probably be looking at an administrative suspension. So please, if you are audited, do not respond. 27 of those cases were referred to my office for investigation. And the referrals were because there was an indication that those 27 members had filed out false compliance cards. That's how people come to my office. You don't come to my office if you just are not in non-compliance regularly. That doesn't happen. What happens is the people who are auditing it, if they determine through their audit, and this is through communications with the attorney, that it looks like the attorney actually falsely declared compliance. And these compliance cards are under penalty of perjury. Then they come to my office as a referral and enforcement matter. In 2011, based on a 1% audit of the membership, 27 referrals came to my office. In 2012, the audit increased to 5%. In 2013, this year, it went to 10%. It is my understanding, this is what was reported to our Board of Trustees just a couple weeks ago, that the audit team who did the audits for 2013 anticipates that 175 referrals are going to come to my office. That's 175 referrals for a potential violation of community moral turpitude. So I'll get to that a little bit. So I'm hoping, clearly people here, you take your MCLE requirements seriously, which is good, but I'm hoping to get out the word to more people that it is very important that people comply with the MCLE. And if you are randomly selected for the audit, that you are working with the audit team and responding and not just ignoring it. So let's go through the basics of MCLE requirements. As you all know, you have 36-month period. If you are in the reporting group, you've got to report for the year, and you've got to have completed 25 credit hours. The credit obviously has to be for MCLE approved courses. Not any course qualifies, so people should be aware of that. If you are an attorney who is on administrative suspension or discipline, it does not mean you don't have to comply with your MCLE. There is no pro rata calculation. You still have to comply. If you are voluntarily inactive for a portion of that time, then there's this pro rata formula that you can just go to the website and it'll help you figure out how many hours that you actually have to report for. The reporting requirement does not require attorneys to submit proof of attendance. So let me say that again. The reporting requirement, so if I'm part of the group that's that has to report compliance, when I report that compliance and I submit to the state bar, I have in fact completed my MCLE. I don't have to submit proof at that time. However, if you are audited, you will be asked to submit that proof. And that's why it's very important for you to keep good records, for everyone to keep good records of the programs that they attend and the courses that they attend. And you're required actually to keep those records for 1 full year. But obviously, if you are not in the reporting period for the year, you should keep those records until you're reporting, and I would say until a year after your reporting period is over. That is the best thing for you to do. It avoids you having to try and reconstruct history and contact all these different courses and organizations to see if you can get a resubmission of your copy of attendance. So again, non-compliance is not misconduct. And what I mean by that is if the state bar contacts me and I have not done my MCLE for the year, that alone does not mean it's a possible disciplinary offense. That doesn't come to me. The things that come to me again is when someone has falsely declared under penalty of perjury that they have in fact complied with their MCLE. Non-compliance for MCLE is an administrative function. It's an administrative function. And what I mean by that is if you are an attorney or there's an attorney out there who hasn't complied, as you may know, this can result in an administrative suspension. That suspension is administrative, it is not disciplinary, and there's a big distinction that I'm going to talk about a little bit later on. So again, it doesn't subject an attorney to my office or the discipline process. You would not be disciplined for that, but you would be enrolled inactive on administrative suspension. So noncompliance is defined in rules 2.90 through 2.93. Failure to complete the required education during the compliance period or extension if granted, that's noncompliance. Failure to report compliance or claim exemption from MCLE requirements, that's noncompliance. Failure to keep a record of MCLE compliance, again, because everyone is required to maintain records for at least a year. Or failure to pay fees for noncompliance. That is what is going to trigger sort of the noncompliance administrative aspect of the MCLE. So what happens if someone is non-compliant? A notice of non-compliance is set. The terms of this are provided in Rule 2.91. And we have a pretty good website. If you have any questions about your MCLE requirements, your reporting time, calculating any pro rata calculation, anything like that, everything I'm telling you, you can find on our website as well. But a notice of compliance will be sent out to the attorney saying, you have not complied. Compliance reporting deadlines is February of every year. Extensions can be requested and given. There is a late fee associated with that, and the deadline is June 30th. So inactive enrollment. What I was saying earlier is if you are in non-compliance with your MCLE and you don't get that straightened out, you will probably be placed on inactive enrollment. And that inactive enrollment means that you are not allowed to practice law during that time. So it is important for people to make sure that they are complying. Even though that alone would not subject an attorney to discipline, if someone is on administrative suspension and during that time they are practicing law and my office gets a complaint, that is a complaint that we investigate and we frequently prosecute. And I cannot tell you how many times in those situations the attorney's response or position is, well, I was only in that status because of MCLE. It wasn't like I got into trouble with MCLE. It doesn't matter. If you are on inactive enrollment, whether it's because of MCLE or otherwise, you are not allowed to practice law. And so if you are practicing law, meaning you're still the attorney of record, you're appearing in court, you're consulting with attorneys, and a complaint comes to my office, we do investigate those cases. You remain on inactive enrollment until submission of proof of compliance and payment of obviously any late fees. So generally speaking, it's relatively easy to come off that suspension, that administrative suspension, once you are in compliance and again you submit the late fees. And again, I just will emphasize again, you cannot practice law, however, if you are on that administrative suspension, because practicing law while you are on suspension, whether for MCLE or otherwise, is a disciplinable offense. So how can MCLE get you into trouble? As I indicated, referrals that come to us are cases where the state bar has determined in the audit team that the attorney involved actually filed a false compliance card. And again, those false compliance cards are under penalty of perjury. So, like I said, in 2011 was the first year that the state bar did audits. It was the first year that they submitted referrals to my office, and we have filed charges in those cases. The charges are the same for every case. It is an act of moral turpitude. It is a violation of Business and Professions Code 6106. And that particular violation, under our attorney standards, which is our guidelines, the equivalent to sort of sentencing guidelines, the standard, the presumption is actual suspension. I cannot stress that enough, because the people who actually end up in our system find it difficult to believe sometimes that they are looking at actual suspension over something that stemmed from MCLE noncompliance. But again, the disciplinary offense that's in play by the time it gets to my office is not mere noncompliance. It is a false declaration. It is a false declaration. And so the cases that are public, that have been filed and have proceeded to trial or through settlement, have ranged anywhere from state suspension to actual suspension, 30 days, even 60 days, depending on the circumstances of the case and any aggravated or mitigating circumstances. So it's significant. And when I tell people that, they're always a little bit surprised at what they think is a severe or significant discipline, actual suspension, because they tend to look at it from, well, this is MCLE noncompliance. Again, my whole goal when I talk to people about the MCLE audits is to ensure that people don't come into the disciplinary system. I certainly don't want to see lawyers in there for the MCLE noncompliance, false declarations. Nobody wants to be there. And we try and do as much outreach and education to people to be aware that the State Bar is auditing, and the audits are very serious. And if you end up being referred to my office, it could lead into a permanent mark on your record of public discipline and actual suspension. So, if anybody is familiar with the cases that have actually been filed, again, gross negligence comes into play. It doesn't have to be intentional. It can be through the gross negligence. And so clearly, this is no surprise, the record keeping that attorneys keep is essential, Okay. I want to talk to you a little bit about our ethics hotline. So the ethics hotline of the State Bar, you can find the phone numbers on the website, but I'm providing them here as well. This is a great service that the State Bar provides. It does not come out of my office because my office is the prosecutorial office. We don't give advice, but we do have an office of competency. Their folks run this ethics hotline, and what they do is if an attorney calls, and this is designed for attorneys, and the attorney has some questions, they're seeking some kind of guidance, these people are professionally trained to help the attorney and guide them to the right resources so the attorney can make an informed decision and hopefully stay out of trouble. So the ethics hotline is fantastic. I want to talk to you a little bit also about what's happened with the State Bar in the last couple of years. In 2011, the legislature basically reminded the State Bar of our public protection goals. The State Bar of California is not a bar association, we're not a trade association. And in 2011, the outside stakeholders, the legislature, as well as the Supreme Court, which I'll talk about in a little bit, really was giving significant messaging to the State Bar to refocus on public protection. And what I mean by that is my office, which is the Office of Trial Counsel, our primary focus is the public. Our focus is to protect the public. Our focus is not membership assistance. And that is an important distinction, and some people sort of disagree with me on that, but that exactly is the case. The regulatory function of the State Bar, my office, we're there for the public. We are not there as an advocate for the attorney. And so when I talk to attorneys, I remind them of that we are not a trade association. In 2011, we began a governance reform of our Board of Trustees. So we had a Board of Trustees in 2011 that was 23 member. We are reducing that down to 19. Through that governance reform, there are fewer elected members. There are more appointed members. So now the Supreme Court, for example, has 5 appointments to our board. The governor has 4 appointments to our board. The Senate and the Assembly have appointments to the board. And that is slowly changing the composition of the board. It's reducing the size of the board. And again, this is all in the efforts to refocus the State Bar's attention towards public protection. In 2012, the Supreme Court also sent messaging to the State Bar. Some of you may or may not be aware. But in 2012, we had something fairly unusual happen, and that was the Supreme Court in 2012 actually sent back 24 cases back to the State Bar Court. So I indicated to you before that the process generally for discipline is the State Bar Court will make a recommendation. Let's say the parties enter into a stipulated settlement. That stipulated settlement is submitted to the State Bar Court for review. The State Bar Court reviews it to determine whether or not it thinks it's appropriate. If so, it will issue out an order approving the stipulation and submitting it for recommendation to the Supreme Court. Same thing with trials. If the case goes to trial and the State Bar Court decision is that the attorney should be disciplined and suspended, it's a recommendation that goes to the Supreme Court. In 2012, 24 settlements, that means stipulated cases by my office and the respondent, approved by the State Bar Court, transmitted to the Supreme Court for approval, were rejected and returned. And in the return, there was an order from the Supreme Court. It was a short order that basically said that the State Bar should reconsider these cases, the recommended level of discipline, and cited 2 cases. And those cases were cases that pointed out the significance and importance of our attorney standards, our guidelines. That happened in June of last year. In July, the following month, my office identified other cases that seemed similarly situated to the 24. And we requested that the Supreme Court also then return those 24 cases to us. The Supreme Court denied our motion on procedural grounds, but actually sent back 18 of those 24. So we had approximately 40-some cases come back. And again, what is significant about that is that all the parties, the attorney, my office, and the state bar court had thought that that was an appropriate level of discipline for the Supreme Court to review and accept. Those cases, most of them have been completed. A few were resettled through stipulations, but the vast majority of them actually went to trial. And the vast majority of them are submitted to the Supreme Court. The Supreme Court has generally approved the recommendations. Not all of them, some of them are still in the process. But what is significant about the end results of those cases is most of them went back up to the Supreme Court with a greater level of discipline recommended. And so the state bar has been going through the last couple of years some real re-engineering. And one of the big items for our board of trustees this year, this new year, which is October to October, is to take a look at those attorney standards. So the attorney standards, if anybody finds himself before the disciplinary system or knows someone who's through the disciplinary system, the attorney standards are online. You can take a look at them. And those are guidelines to give attorneys a general idea of the types of recommended sanctions based on the misconduct involved. So again, I talked to you about the MCLE cases. When a false compliance case is filed in state bar court, the charge is moral turpitude. The standard that applies is standard 2.3, and that standard, the presumption, is actual suspension. Those standards, however, have been in place since the 1980s. And so because of that, the board is taking a look at those standards again, particularly in light of the remand and the return by the Supreme Court last year to see whether or not those standards need to be revised. So that's going to be a long, thoughtful process. It'll be interesting to watch and see whether or not the presumptive ranges of discipline change for those acts of misconduct. But I think if you talk to people who are actually in the discipline system, defense counsel, my office, people who are there, we are generally seeing an increase in the level of discipline recommended. And we're certainly seeing an increase in trials because of that. So it's been an interesting time for the bar. Hopefully this is just informative to you. But again, if you have questions, our website is a fantastic resource. There's a lot of information up there. All the rules, all our procedures are easily there. But again, this ethics hotline is really great too. I think it is one of the most wonderful services that the State Bar offers to attorneys because again, the State Bar is interested in offering guidance to attorneys when you need it. I know that we only have about 10 minutes left, so let me open it up for any questions if anybody has any general questions. Yes?
Website.
Yes. It's calbar.org, www.calbar.org. And so I always tell attorneys, because there's a lot of information up there, usually what the attorneys are interested in seeing is the links on the left-hand side. Okay, so you can see there. As well as there are tabs across the top that will direct you to various sections of the bar, but that left-hand link, I think, is where you're going to want to go. It talks about resources available to the public. It talks about resources available to attorneys. Yes. Do I have any other questions? Yes.
How rare is it that someone's prohibited from practicing in the state of California and do a disciplinary action?
How rare is it?
Yeah.
Well, I guess I wouldn't say it's that rare. If you're in the disciplinary system, there is a significant chance that you're gonna have discipline. And what I mean by that is just recently we had gotten some data from our state court because one of the questions that we had asked, that was asked of us is, out of all the decisions or orders coming out of the court, how many result in dismissal versus how many result in some kind of discipline or favorable finding in the state bar? And it was like 99% of the cases resulted in some kind of order. So if charges are actually filed, there's a significant, I think, likelihood that there is going to be some kind of discipline imposed.
I'm not asking about some kind of discipline. I'm asking to be prohibited from practicing.
You're talking about actual suspension?
Yeah.
Okay, so...
And permanent suspension. How uncommon is that?
Well, we don't have permanent disbarment in California. There is no permanent disbarment. So I think you're talking about if there's a disbarment order If there's a disbarment order by the Supreme Court, then obviously an attorney is prohibited from practicing law until they are reinstated. There is no permanent disbarment, however, in California. And so what that means is a disbarred attorney or someone who resigns with charges pending, they are out for at least 5 years. And what I mean by that is an attorney cannot petition back to get reinstated until after a 5-year period is over. The 5-year period is no guarantee that you come back. It just is the first time you can actually petition to the court to actually come back into practice. And if that happens, there's a whole proceeding that goes into place, and the attorney obviously has to demonstrate rehabilitation, competence, etc. like that. So that's one thing, disbarment. Another thing is actual suspension. When the Supreme Court approves an actual suspension order, the actual suspension orders generally are, the periods are generally 30 days, 60 days, 90 days, 6 months, 1 year, 2 years, or more. Generally speaking, if an attorney is suspended for 2 years or more, the court will also impose a condition, which is a mini reinstatement proceeding. What that means is it's 2 years minimum that you're out, and you have to have a mini reinstatement proceeding to come back in. The burden of proof is less. It's not as onerous and burdensome as the actual disbarment reinstatement proceeding. But again, that's an extra condition, so it's a minimum of 2 years and until that. So again, though, if an attorney is subject to an actual discipline order, it's the Supreme Court that issues that order. It generally goes into effect 30 days thereafter, and then the actual suspension starts. That suspension period is monitored by our Office of Probation. Let me tell you a little bit about sort of the process, because people often ask me, well, what if the suspension order comes and I'm just not prepared because I thought I had more time, etc. The way that the formal disciplinary process works, the attorney has a lot of time actually to prepare for any actual suspension. Because again, what's going to happen is there's going to be a recommendation by the state or court, whether it's because the party stipulated or whether it's because it went to trial and the court issued out a decision. Then the court actually submits it to the Supreme Court. So when people ask me generally how long does it take for the Supreme Court to issue out that order, generally speaking, you're talking about 3 months. It's about a 3-month period of time. Of course, that's not a set time because we don't control exactly how quickly the court is going to submit it or how quickly the Supreme Court actually sends it back. But roughly speaking, it's about 3 months. So people have plenty of opportunity to actually prepare. The other thing that I do want to mention too is in the system, if someone is disciplined, the actual suspension is 90 days or greater. The State Bar Code also imposes what's called a Rule 9.20 requirement, and what that means is based on that amount of suspension, basically, the court is saying, in addition to being suspended, you, attorney, have to notify all your clients, public counsel, the court. That's a separate order, and that order is a separate order by the Supreme Court, and a violation of that order alone can result in a whole new disciplinary proceeding against you. I think there was another question.
I was going to ask, this body that you mentioned that will be looking at your standards or your sentencing guidelines, if you want to call them that, who is that? And also a follow-up to the thing about the reconstitution of your board. Is the whole attempt to lower the number and pack it with people that are non-attorneys to change the orientation and the, I guess, biases, if you will, of where people are coming from?
Sure. So first, let me talk about the first one first, which is the attorney standards. The board is authorized to put together a task force. The task force has not been put together yet. In fact, the action approved by the board to do that just occurred. So a task force is going to be put together. We're waiting to see exactly how large the task force is and who is on it. But what the board has indicated is they want to make sure that all stakeholders are on it. So not just, for example, people from my office. It would be people presumably from the defense bar, etc. So that we're waiting to see. In terms of the governance reform, yes, I will tell you, I think, I wasn't here when the governance reform started. I didn't return to the state bar until the end of 2011. And so the governance reform work began in earlier 2011. And I think it's safe for me to say that it was a perhaps painful process for the board to go through. And the idea of, again, refocusing on public protection, I think the idea in terms of the appointed members is that it's not people who are being elected. So for example, if people are paying attention to the sort of the state bar board election process, it's people who have a campaign statement. You may or may not know much about them. You may or may not follow them. But it's the selection process. Obviously, in the appointed process, there is a vetting process that goes through any appointment appointing court. So, for example, the Supreme Court. The Supreme Court has 5 appointments. They have filled 3 of those appointments already. Those 3 appointments are filled with all Southern California people, so we are anticipating that the next 2 will be Northern California. But if you look at the people that they have appointed, these are people who have a long and distinguished background, I think, in terms of following lawyer issues. Some of them come from bar, some of them come from legal services. But I think you're seeing, again, through that appointment process and vetting process, just greater consideration of who is going to be on the board, and to make sure that the people on the board remember that as regulatories, our focus is with the public. And if the public interest is adverse to the attorney interest, it's the public interest that is the one that is paramount. And in fact, if you look at the legislation from 2011 that basically reminded the state court that your focus is public protection, that's what they're saying. And even if in the attorney standards, there is a standard that talks about the purposes of discipline and rehabilitation. Well, it says rehabilitation is appropriate only if it doesn't conflict with another priority. And so again, the idea is the paramount priority is public protection. Any other questions? Yes?
The impact of suspension on receipt of attorney fees and employability during suspension.
I'm sorry, can you just clarify?
If an attorney is suspended and they get attorney fees for a case they're still working, is that impacted? And if they are suspended, can they just work for another attorney? Okay.
I will give you my disclaimer, which is, as the chief prosecutor, I cannot give any legal advice, but I will point to certain things that hopefully can provide you guidance to make an informed decision. If you are suspended, if an attorney is suspended, you are suspended. It doesn't allow, that means you can't go and work for another attorney as an attorney. It doesn't. If you have cases, again, so what's good about the system is if an attorney is looking at actual suspension, that attorney has time to prepare. Because it takes about 3 months after the state court's trial decision comes out or after the parties submit a stipulation saying that this attorney is going to be suspended. And that provides the attorney sufficient time to take care of business, which is to figure out what you're going to do about the cases, if they're going to be reassigned to somebody else, if you have unearned fees that need to be returned, etc. So that's the period of time that attorneys really should be using to make sure that when the suspension goes into effect, they are really off. Don't be an attorney of record. Don't have a voicemail that's open that says, and indicates to the public that you're still open for business. That can cause someone to get back in trouble. Because a violation of unauthorized practice of law is not just that you're in court practicing. It is not just that you are consulting with a client. It is not just that you are actually filing pleadings. It also includes if you are holding yourself out publicly as an attorney. And what I mean by that is it is not uncommon for cases to come to us because someone is on suspension, and during that suspension, they keep their office open, they keep their phone lines open, they keep their website open, indicating to the public that they can work cases, and what they do is, well, I'm not going to actually actively work on it until my suspension is over. That is a case that will come to us, and if it comes to us, we will investigate it because it's a potential problem. Any other questions?
It looks like
Yes.
we're done with that. So
Yes.
I want to thank you very much for that.